All right. So, welcome. Today is January 24th. We're here to do some legislative review, talk about some of what's going on in the legislature, things coming up. And there's just a few of us here today. Not a lot so far. Hopefully a few more join. But if you have bills or issues that are of concern to you, please let me know as we go through this, because we'd love to focus on those who have joined and any concerns that they have. So let me know here if there's anything you'd like to discuss.
Hey, Austin, this is Janet.
Hey, Janet.
I am interested in HB 131.
Okay.
And there's a hearing today, but they just this morning announced amendments, and I went through them, but I'm kind of confused about how to incorporate those into my understanding.
Yeah, so that's great to go through.
I'm just
Let's
wondering,
see.
my impression, but I'd like to know what you think when we look at that, is that they've really watered it down, but I don't know exactly what they've done.
So let's pull up HB 131. And you say that there is an amendment on this bill?
Yeah. Yes, they just amended it.
Okay, let's see. And so this looks like it's going on in committee. Is it going on as we speak here in committee?
I think 2:00 today.
Okay. Let's see what amendments are proposed. See one of them. And then the last one. Okay. So each amendment is coming, well, just kidding. So Norman Thurston is proposing 2 amendments, and Walt Brooks, sponsor of the bill, is proposing an amendment as well. And so we'll look at those and ways to understand those. But HB 131, to give kind of an overview, is the vaccine passport prohibition, which in general, a place of public accommodation, store, hospital, certain things where the public goes, they're not supposed to ask you to see whether you're vaccinated or not in order to receive services there or be a part of what they do publicly there. And then it gives the same, they don't want the government from requiring proof of immunity status, and they don't want an employer to require proof of immunity status. Each of those has a few limited exceptions that we can look at. If you look at the bill, let me pull it up on the screen. Share this screen. We have this vaccine passport bill. So we have the bill sponsor, Walt Brooks. Then they list all these co-sponsors. So co-sponsors are people that want their constituents to know that they also essentially feel the same way. They're pushing the same thing. This was a bill, I think, that came up last year. Didn't quite make it through, but there is a fair amount of support for it when you see that many co-sponsors. And so here you can see, again, the underlying portions are things they're adding in, telling people what they can or can't do as it relates to vaccination status. And then if you go over here to these related documents, these haven't passed yet. Or so it would show up here that this had been amended. So for example, if you go back to the list of bills, and they will tell us, like on HB 118, it says substitute. This is different than the original. It's a substitute bill that's now been approved. So when it says substitute, it means it's been approved. and it's actually operative. But right now, HB 131 is showing us amendments that are proposed. And then they're going to make these in the committee meeting today to talk about this. And so if we look at them, if you click on those, this is amendment number 1. And what it's doing is it's showing you what's changing with colors. And so the blue is showing you what did exist. So if you look at the original text of HB 131 and you go to lines 82, 83, and 84, you'll see that this amendment, this line 83 amendment, takes out degree granting and puts in the word "and." And so it used to say a vaccination requirement by a degree granting institution of higher education, which would mean that they would have the ability to do some of these things if the requirements in accordance with 53B-2-113. Now it's any institution of higher education, even if they don't grant degrees. So most likely some public institution somewhere said, hey, this will affect us. We won't be able to require vaccinations because we don't grant degrees. And so they most likely reached out to Walt Brooks, or somebody did, and said, hey, you need to change that little term because it drops us out of this. And just so you know, the section 53B-2-113, institutions of higher education can require vaccinations for students if they also give the students the ability to state an exemption. Essentially, they can state a medical, personal, or religious reason for not getting vaccinated and provide those, similar to the way that K-12 schools work right now. They took out the line "or," which may mean that they're trying to make it more inclusive, or maybe they just had an "or" in there too many times. We can look at that on lines 96 through 97. The lines are here on the side of the page. And so we're looking at E, F, G. And so now this would say subsection 3 does not apply to, and that looks like they're just trying to make clear that it doesn't apply to everything in A, B, C, D, E, F, and G, because "or" before could be interpreted to mean only one of them. And so I think they're removing that to say it's making it just clear. So statutory interpretation, it doesn't apply to anyone listed in that A through G portion there. And then lines 103 through 104, you look at, used to be a period at 104. And this is someone, I think, that is exempt from these requirements, which means they can require vaccinations. And they're putting in this, they're proposing that a government entity be allowed to require vaccinations if they can show that there's a nexus, which means a connection between a vaccination requirement and the employee's assigned duties and responsibilities, or there's an external requirement for vaccinations. So for example, if a government position required travel to Canada and Canada required vaccinations to travel, the government entity would be able to say, if you want to fill this position, you have to be able to show proof of vaccination because you have to be able to travel. So that is one example of a requirement that's imposed by an external force, essentially, that an employee may have to be vaccinated for.
Okay, that's good.
And then they go down here. This one's actually a little concerning that they're removing this portion, these lines 106 through 111. Should probably look at that, see what's happening. So the government entity described in 3G. So 3G used to let people in the health and medical settings get exemptions still if they could show that they'd be injured by the vaccination, that it conflicted with a sincerely held religious belief, practice, or personal belief. They're removing that and essentially saying that if as a part of your duties, you're exposed to human blood, fecal matter, or other infectious materials, you can be required to be vaccinated. So I'm betting that the health entities, University of Utah Healthcare, for example, has pushed back on that, saying we have to require people to be vaccinated if they're doing these things. And it sounds like they're proposing to concede to that with this amendment. So this would
So
allow a
it's
few
not,
more people.
is that just government entities or?
Yeah, so this one applies to government entities, but remember that University of Utah Healthcare counts as a government entity.
Yeah.
Because University of Utah is a government entity, and any health program run by the government would also fall under this.
Hmm.
So I'm just curious because haven't there been enough cases that have gone to court of different, entities that have mandated the vaccine and then it's been proven unconstitutional? I mean, isn't there enough standing now? I was late because I was responding to, I wrote all the legislators this morning in the committee meeting. I can't go today, so I want to be sure at least write them. And I got a response back from one of them, and he, I love the dialogue, but he was defending his position that he couldn't support this bill because he felt like it was an infringement upon personal businesses, to be able to have the ability to run their businesses as they so choose. But isn't that unconstitutional? Like you can't, and hasn't that been proven in court? I mean, repeatedly now?
No, unfortunately. The constitutionality is in question of a number of things, but you have to remember the Constitution restricts the government's ability to tell you you have to do something or not do something. The Constitution doesn't apply in most situations to private actors. So a business, if I'm an employer and I say, if you want to work for me, you have to be vaccinated, the Constitution doesn't touch me because I'm not a government actor. And so there's a lot of businesses that are mandating that employees get vaccinated or telling visitors. So for example, hospitals and doctors' offices want to say, hey, if you want to come here, we want to require vaccination. We'll only treat the vaccinated. And so what's happening, this vaccine passport ban is saying we are proposing that private people that aren't covered by the Constitution be banned from mandating that someone else have a vaccination unless they're part of this exemption list. And so there are a number of legislative reps that said, well, we believe in the freedom of people. We're not going to regulate business. We don't believe that's appropriate. I think Libertas Institute takes that position that, hey, we can't tell a business what to do or not to do. And I think in general, it's wise to understand that we shouldn't regulate business too much. But from the beginning, we've recognized the need to regulate business to maintain competitive measures, to maintain a free market. And we've done that through anti-monopoly laws, through antitrust laws, through a whole host of laws that businesses will abuse power that they have. And we often say, for example, oh, I don't want to take away an individual's right to direct their business. But we don't have the discussion that there's a big difference between, me, if I'm an employer of 1 or 5 people, that's a big difference between something of like Google. Google's owned by the public, doesn't have a private owner, it doesn't have one person whose moral or religious beliefs are being protected or not protected. And there's a wide disparity in business types. And when you get companies like Google or Amazon that can say, oh, if you want to work for us, you have to be vaccinated. People are in a scenario where they have a livelihood, they're dependent on that income, and they're not necessarily free to just change employment whenever willy-nilly the employer imposes a new requirement. And so there's a debate currently in society as to whether the government should protect the individual freedom to be free from a vaccine mandate, or they should protect the freedom for an individual that owns a business to mandate vaccinations for their employee. And that's where a lot of that debate comes from, even among the conservatives. It's a pretty strong split.
So these cases like in New York where I mean, didn't they have to, they had to reinstate all those nurses? Is that a government entity? And didn't they have to provide back pay?
So there are some situations in New York. I think there are some places where people have won, but what they win under is not the Constitution. They're winning under things like state laws that are in place that prohibit firings for certain reasons, or that require you respect. So there are some state laws in effect in different states that require you to not discriminate against people with certain religious beliefs. And so if people could show that they had a very strong religious belief against vaccination and they were fired for not getting vaccinated, the state law may kick in to say, hey, employer, you can't fire someone for their religious belief. So state by state is kind of a patchwork of reasons why people have been reinstated, but it's not consistent. And in Utah, there's not a lot of protections, especially on the religious grounds, because the churches in Utah, almost all of them, have fully supported vaccination.
Right.
And so we can't,
So
people here.
There's no protection for individual liberty then, it sounds like, is what you're saying. The Constitution isn't, I mean, they didn't say anywhere I just thought, I mean, they didn't say in the Constitution that our basic liberties and, personal rights to govern our own bodies are valid until a pandemic. Like, I don't understand how the Constitution doesn't protect our individual choice to put something in our body or not.
Well, it's because of the way that the word choice is used. And so let me just give you a simple example of when choice conflicts, even under the Constitution. So the Constitution was written to restrict government. So it was to say, government, you can't do X, Y, and Z. So the freedom of speech, for example, is something the government can't take away my freedom of speech, but Google can say, we're not going to post any content that is, with the color purple in it. You put purple in it, we're just not going to post it. They could choose to do that if they want to, because they're considered under the law a private actor, and they're saying that. But to break it down into a simpler example, in my house, I can choose who comes in and who doesn't. And I can say to someone, hey, you're only welcome in my home if you're vaccinated. I have that freedom as a person to say, this is my home. You have to be vaccinated to come in here. And someone could say, well, I'm not vaccinated, so I guess I can't come in your home. And then they make the choice to not come in my home. They know the requirement to come in. But me as an individual exercising my personal liberty, I say this is my space, my control, my dominion. I get to choose what happens here. And the law generally, under the Constitution, has respected that, because the government's not supposed to interfere with my freedom of choice about my things within my dominion. So the debate right now in society is really, the push is, what level of dominion is necessary for a business to have over us in order to protect their rights versus our rights? Because right now, with this health issue, with what goes in my body, the question arises, well, should an employer be telling their employees what they have to put in their body? Should an employer be able to say, you can only work here if you get a tattoo? We require all employees to have tattoos. And then the government might say, well, I'm not going to outlaw it, because if you don't want a tattoo, don't work there. You have the freedom and the choice not to work there.
So what happened to HIPAA in this mix? I mean, wasn't
Yes, HIPAA's an amazingly ineffective law, because it generally regulates healthcare providers. It doesn't regulate voluntarily giving up medical information. I can go post any of my stuff on Facebook. The hospital can't, but I can share everything. So we have all these, HIPAA laws in place for confidentiality on Facebook anyways. But if the employer says, hey, disclose something to me that you have the freedom to voluntarily disclose, or you don't work for me, then again, the law is taking the position that that's your choice. You're choosing whether to exercise your right to keep that confidential or to disclose it. If you don't want to disclose it, then go work somewhere else, is what they say.
Mm.
And so it's produced a very intense debate in a lot of realms, conservative and liberal, like, because there's a lot of liberals that don't want to be told what to do with their body, what not to do with their body. There's a lot of conservatives that don't want to be told that. But there's also a lot of business owners that say, I can say whatever I want in my business. The government can't come tell me what employees I have to hire, which ones I don't have to hire. You know, if I'm terrified of the pandemic and there's 3 of us in an office, I should have the freedom to say I only want to work with people that are vaccinated. And that's where it becomes interesting of, can we segregate into these groups or situations where we maintain these freedoms, or are there certain freedoms that we just say, no, you can't make requirements based on that. It's not even relevant to what's going on at your place. You know, so again, just going through different examples, tattoos, certain haircuts. Can we require that all our employees have purple hair? Currently, yeah. And we can fight and scream if we're an employee and say, I don't want to dye my hair purple to keep my job here. And the government says, okay, then take another job. No one's making you stay. And so an employer mandate for vaccinations is not seen as a mandate by the government because you have the freedom to quit.
But having purple hair doesn't injure you. Okay, you might not want to have purple hair. I mean, my brother-in-law died 5 hours after he got his shot. I have a whole litany of another friend's daughter, 18-year-old daughter, just died last month unexpectedly at college. I mean, the health issues of people that I know personally. I mean, and it's now just becoming fact and evidence that this was mandated, and there is a whole percentage of the population it has seriously adversely affected. So to be forced to do that, it just seems like that there is a level of harm here that this vaccine has caused, that it was forced into people, that there's no way to protect people from having that liberty to say, no, I don't want to do that.
Well, again, and I actually agree with HB 131. I think we should have a vaccine passport ban personally. I'm just trying to share with you the other side so you understand it.
I totally appreciate that. I want to understand this.
Angle. Is that, so let's take another dangerous activity. Let's say that if you want to work for Red Bull, the company, you have to go participate in one of their extreme events. You got to do extreme skiing, you got to do extreme motocross, you got to do extreme something, and people are injured all the time, crazy injured all the time. But Red Bull says, we only want people that, you know, this is their life, this is what they do, this is what they live or die on. The government would look at that and say, you don't have to go. If you're worried about that injury, if you're worried about the consequence, why work for Red Bull? Get a different job. And so the legal theory underlying the law of labor in Utah is it's an at-will state, which means you have the freedom to quit at any time. You're not locked into employment. And in order to have that freedom to quit at any time, there are some responsibilities put on us because rights always follow responsibilities. If we want the right to do something, we have to have a responsibility. And so one is, if we want the freedom to be able to quit and move jobs at any time without being stuck into it, or being stuck into a union or different things, then we have to take responsibility to leave our job when we don't like what the employer's doing.
Okay.
Because those two go hand in hand generally. But on the flip side, and this is the piece that's left out of it, and this was my push, my proposal with this issue, is I said, well, I'm very comfortable. We could stop all employer mandates of vaccinations by keeping rights and responsibilities together to say if an employer wants the right to mandate a vaccination, then we just say, okay, then take the responsibility to pay for any damages that come to that employee for the rest of their life.
Okay.
And if you have a brand new vaccine coming out, it's being rushed through, it's on emergency, use authorization, and you tell an employer, yeah, you can mandate it, you have that freedom, But if you're going to do that, you're paying for everyone that's damaged by it. And those damages could accrue for the next 20 years. Businesses aren't going to mandate it unless it's just absolutely
Right.
essential to their business.
Right. That makes sense.
Yes.
And then we're keeping, again, the rights with the responsibilities. Say, okay, you want the right to ask someone to do something super harmful? Okay, we'll keep that right with you, but pay for it. You know, because what's happening right now is the employer has the right to mandate it, and then the employees are just left on their own for the damage and the harm and everything else that comes with it as a result. And so to me, the solution to properly balance those two is keep rights with responsibilities, but tell the employees, hey, if you got a bad employer and they're mandating something bad, you got to quit, move on, go find someone good to work for. You know, have it be the employer's loss, but on the employer side too, saying, okay, if you're going to mandate that, be responsible for it.
Yeah,
And
that makes sense.
what's interesting, Austin, is now they're finding that the life insurance companies, the disability insurance claims are really high, especially in the employer group plans. And there's a guy, Edward Dowd, who's diving into all of this and reporting the data. And it's shocking. It's shocking. And you would think that employers would wake up because they're going to pay for that eventually, you know, through their premium, because a lot of these are offered to employees as a benefit. It's just crazy that employers are still going along with this.
Well, again, it's one of the things that happens when you have third-party payors in place is when you have insurance, it can incentivize greater risk taking if someone else is on the hook for it. And so even if you have workers' compensation coverage that might kick in, what workers' compensation coverage does, they did a trade-off in the legislation with employers where it's capped. There's only a certain amount of liability they'll pay for, and they can't sue the employer for additional damages beyond that. And so if you get a workers' comp payout through the insurance, it's capped, it's set to a certain fund and things, and the liability to the employer is capped, where now the employee can't sue the employer for everything they would otherwise get. So when an employer purchases workers' comp insurance, which is required to do by law, they get benefits of reduced liability. And it's one reason why it incentivizes risk taking for businesses, because they don't have to worry about the consequence of it.
Oh, that's interesting.
Interesting.
And again, it's as we look at when you separate rights from responsibilities, it creates all kinds of perverse actions and things. And I just, again, my thing was to say, well, you know, we have, if you want the freedom, if you're saying as a business owner, you need the freedom, okay, just be responsible for it.
Yeah.
And again, I think that would have virtually shut down all vaccine mandates, almost all of them.
Yeah.
Because
Yeah.
if you're going, if this vaccine does something to someone in 20 years, I have to pay for it. Not worth it.
Yeah.
So this bill, it appears that this bill is basically confirming that government entities of any kind have to conform with the employee mandates. Is that
The government
correct?
entities in the kind have to do what?
That government entities have to conform to the employee mandates.
Which employee mandates of a private employer?
Of a healthcare, for example. But everything in there appears to be government. They're protecting government from being able, whether it's a university or a healthcare institution, to continue to require these mandates. Am I reading that right?
So the general reading of it is government can't require a vaccine unless they fall into one of the exceptions. So healthcare is a very strong exception. One reason that's so protected is because the federal government has a mandate in place about recipients of Medicare and Medicaid funding and having to vaccinate people. And so if Utah said healthcare couldn't force vaccinations, they could lose all the Medicare and Medicaid funding. But there are some of these other situations that we looked at was if the government can show that an employee's job to fulfill the job duties of that position, they have to have a vaccine. And again, a really easy one to think of is if that employee has to travel outside the country, then the government's saying we need the ability to say, to fulfill this job, you have to show us proof you're vaccinated, because you need to be able to, if we're going to hire you, you need to be able to travel to Canada or Japan or wherever else you may fly to. But if the government can't show that connection and can't show that it's important to that job position, they still can't require it. And so then it's just a question of, well, how far out does that translate in real life? And some of that's unknown, how far they'll try and push that or not. But in general, the government has really backed off of mandating vaccinations as a government. But there's still this big debate in the private sector where a lot of companies say, we need the freedom, don't mess with our freedoms, don't touch us, we're a freedom-based state. We need to be able to say what type of employees we want, what's required. And this bill is stepping in to say, no employers, you can't mandate vaccinations unless you meet these specific requirements. But to me, again, neither one's the exact proper resolution. The proper resolution is to put the rights with responsibilities.
That makes sense.
Yeah.
And that was proposed. It was in a bill that was proposed. It met incredibly fierce resistance. Where the Salt Lake Chamber of Commerce and other chambers, I think, came out and said, they're trying to make us liable for everything. And it created this huge uproar. And I was going, yep, you're responsible for your actions, so don't make stupid actions. But it was very clear that they understood it caused harm. And we're still moving forward with it, which is, from a societal perspective, very concerning that they know that there's potential harm and still doing it.
Wow.
Yeah. Thank you. That's good.
But yeah,
review.
but HB 31, this is an issue I think that will be going on for quite some time, talking through these things. So
I'm dying. I want to be at that committee meeting this afternoon. I can't make it today, but I'm dying to know. I'm going to try and get on and watch what I can online, but just to see how the arguments goes within that committee. But it's going to be interesting.
yeah, and it is a pretty strong split again across the political parties, whether it's proper or not. So
I've jumped into this kind of late. I'm not sure exactly what the format is. Do we just ask you questions about different bills, or do you kind of have bills that you want to address?
So I always have bills that we can go through and talk about if no one else has anything, but we always give priority to people on to raise concerns or issues they want to talk about. It's one of the benefits of joining the call is you can raise those. So if you have something, you can let us know. Melissa, I'm just going to jump to Melissa quick. And so if you have something, you can tell us after Melissa. She asked, in my opinion, what are the chances that HB 215 does not pass on the Senate floor? I believe it's up for vote today. They're pushing this one through. This is a school choice bill. I would have said last night, I see zero chance it doesn't pass on the Senate floor. They've been working for a year to get everyone on board and get enough votes in place and everything for it. And the amount of groundwork that's gone into it with all the reps and elected officials is huge. But there was the one thing that came up, which, I don't know, introduces some chance, maybe it doesn't, which is, it was on KSL, at least I saw this morning, that they recorded one of the big sponsors of the bill saying that the bill's purpose was to destroy public education, in quotes. So now there's a bunch of legislative reps backpedaling or disavowing, that statement. But Melissa, if that statement makes enough waves, maybe they circle it for a little bit and come back to it to try and clean up a little bit. I don't know. But it has a lot of support.
Austin, there's a petition, you may be aware of it, to separate the two issues in that bill, because they say that constitutionally in Utah, you can't cover more than one topic or issue in one bill. Have you heard about that petition? Do you think it has any merit or chance?
Yeah, I think it has a lot of merit, personally. I think that there's a high risk to the legislature if they do pass it. because the Utah Supreme Court does strike down legislation that violates the one subject requirement.
Mm.
And there are a number of cases where they have done that. And so Melissa says she delivered that petition to the committee yesterday. And they didn't even address it. And I think from the side of those voting on it, I wouldn't be too concerned if they don't address it. Because I wouldn't necessarily expect them to. But what it's doing is it's giving, I think, very strong grounds to be able to go petition a court to say, hey, this violated the Utah Constitution. We asked, it's not like we waited and just snuck this in later. We raised it, we raised the concern, it's on public record. So courts step in and protect the Utah Constitution at this point. And so they're making the claim, they did address it specifically, I think, in the House committee when it was heard. They said, oh, it's one subject because it's funding. And they said, so the subject is funding. But if the court accepts that, which they might, then the Utah legislature would be able to pass bills that cover funding for tattoo parlors and teachers and military and driver's ed and whatever they want, because funding is one subject. And so if the court adopts that interpretation, it would be basically gutting that protection in the Utah Constitution, in my opinion. And I think in that petition, from what I've seen, it talks about a case with motor vehicles where there was one bill that had addressed provisions related to motor vehicle registration and provisions related to liability for drivers of rented cars or something like that. It was something to do with liability of drivers. And so in defense of it, in the courts, they said, hey, this is just one subject, it's motor vehicles. It all falls into the same thing. And the court said, yeah, to some people, motor vehicle registration and liability to drivers could be one subject because it's related to motor vehicles. They said, but to us, it's two. And they struck down the bill.
Mm.
And so I think motor vehicles had a better chance of passing that review of having connection than funding. Funding's a lot more.
It's a lot more
a
broad.
lot broader
Oh.
than motor vehicles. Motor vehicles is at least confined to something else. But to be fair as well, or just to be open about the courts, they are pretty lenient to the legislature in general about what they consider appropriate. But there is a public record of reps that have specifically said this violates this provision. They propose substitute bills on it to split the two. The reason they don't want the two split is because the UEA was able to defeat the school choice bill last year. And they're trying to stop the UEA from defeating it by coupling it with teacher salaries increases. So it's very much a political move. And from my perspective, it's very much two bills. But I do think there is some strong merit to potentially getting a court to kick it out over the two subject issue.
Why do you think they can't just make it a tax credit where you keep the money and you choose where why is that? Why doesn't that ever get anywhere?
I think it does in some circles, but it gets stopped because most of the people that have a bunch of kids in school age kids, they're not paying a lot in state taxes, income tax. And so to do a tax credit doesn't give them a lot of money back. And the people that are really paying the money for this are richer people with kids that have moved out, people that have had a career for 20, 30 years. They're paying substantial amounts. And so if you want to help a low-income student get out of a Title I school, for example, a tax credit is not going to do that.
I see.
And so for the representatives that really want to move kids out of these Title I schools, give them a chance at private school, give them a chance at homeschooling, a tax credit won't accomplish that for any of them. And so it's a nod to the rich, doesn't help the poor kids, and keeps them locked up in the those public schools.
I see.
But in general, there's a lot less strings attached with a tax credit, so far more preferable, but from a freedom perspective. But from a perspective of helping kids in Title I schools to be able to private school, it doesn't do anything. So
Interesting. Okay. That makes sense.
yeah, so it's kind of some of where they go with that. And so I don't know if you guys have more things you specifically want to talk about.
Of lots.
Awesome. Okay, bring it up.
I could ask you questions all day. So have you addressed the two transgender bills, the House, Senate, and have you already talked about that?
We haven't yet.
What is the difference between those two? Do you know?
I don't fully know. We could pull them up and look at them if we know numbers or search them here.
HB 132 and SB 16.
All right, HB 132 and 16. Let's see.
And then I'd love to get your opinion on the ESG bill was just prohibiting ESG scores, I think it was just numbered. It was just numbered. So, but I don't know if maybe like tomorrow night, that would be one to discuss, but I'd love to get your take on that one as well.
Okay, so looking here at SB 16. And also, I guess just real quick, Melissa had a question we didn't address yet. So line 254, let's just jump back to HB 215 real quick before we come off of it. Line 254, let's see. So eligible student, let's see, federal poverty level. Our home-based scholarship student means a student who is eligible to participate, excused from enrollment, and receives a benefit of scholarship funds. So to answer your question, Melissa, line 254 doesn't give or take or create any difference in protections for homeschoolers. It's just a definition about who counts as a home-based scholarship student. And we'd have to look elsewhere in the bill to know exactly what that is. And so yeah, so essentially the definition's changing to say home-based scholarship student instead of a homeschool student. You're now home-based and you're a scholarship student. And then it makes clear in 257 to 258 that home-based does not mean a homeschool student who does not receive a scholarship. So the law is creating two types of homeschoolers here. And we'd have to look at the rest of the bill. But we can do that with specific questions if you want. But it would take a minute here to go through all that. But yeah, 254 itself doesn't create any differences. So, okay, so jumping back to HB 132 and SB 16.
Austin, I heard on the radio today, they were talking about those two bills. The main difference is, and I don't know which is which, but one would totally ban hormone blockers and gender reassignment surgeries for minors. The other one on the hormone blockers would put a moratorium on hormone blockers until a study could be made to determine what effect they really have. They were saying the bills are so similar that if they were to be both passed, it wouldn't make sense because one would kind of conflict with the other, but.
I think
okay, thank you.
It was in the Senate. I was there for that committee meeting and they did a substitute. And they added that hormone blocker piece. So it was the Senate bill that has the moratorium. I think the HB 132 is just starting. I think their committee meeting is today. So it's the Senate bill that has the moratorium.
Yeah, the Senate bill has a moratorium. I was just looking at that. And the Senate has passed some things with it, so it's been referred to the House. HB 132. See, is still in committee, like you're saying. But one of the things I think, at least looking at it from a broad level perspective, HB 132 is banning these types of surgeries in minors. Some additional things that SB 16 is doing is, if you look at the highlighted provisions, I guess I can share here so we can get those. They are creating a certification for providing hormonal transgender treatments, and I assume this is in anybody, even adults. So HB 132 does not address adults, at least based on its title. This one can apply to adults and children. This one does have some things about a minor. So it does have this prohibition for sex change for minors. And so, you know, there's certain things that come into place. There's the moratorium, like you talk about. And then it also extends medical malpractice, statute of limitations. So they're saying if this happens to a minor, you can get sued as a doctor for a lot longer.
Okay.
Minor can take longer to sue you and come back at that.
Yeah.
So these two do have some similarities. They address slightly different topics, and approach it slightly different ways, because this one, 132, doesn't have anything to do with the licensing or the procedures required for a hospital to qualify for that. And Kennedy, who is a doctor and attorney, is trying to put some additional regulation in place to say what you have to be able to show to even qualify to do certain of these things, even for adults.
Okay.
So there are some similarities, some differences for sure. My bet is HB 132 is a little bit more broad with the minors. But these two bills will probably need to be reconciled to really have them be effective if they're both going to make it through.
Yeah. Interesting. So what usually happens in that case? How does that usually go? I mean, with bills that are so similar like this.
So they actually have, so there's a couple of situations where it may happen in this legislative session, where there's different reps that have, they have different ways they want to address concerns within the same statute. And there's a reconciliation process they refer to that says when all the bills get passed in the end, the legislative drafters are supposed to go back through and say, can we incorporate all the changes into this? So maybe what you see as the bill isn't what the final thing looks like, because there was another bill passed as well. But if all provisions can go in without any changes, they'll put them in and just change section numbers or whatever they have to make it work. Those aren't considered substantive with section numbers. And so that's the drafting attorney's job. But right now, when there might be substantive conflicts, they're generally supposed to, the drafting attorneys are supposed to try and alert reps to these substantive conflicts. And then on something like this, that's such high profile, everyone certainly knows there's conflicts. And so the bill sponsors are going to be talking together, trying to figure that out.
Okay.
About what they do, how they do it, which one makes the most sense. Or maybe they just pass both and just say, double protection, we'll let courts figure it out later. That's a possibility. But in general, they're encouraged to reconcile.
Okay. Interesting.
But those are good questions on that. But the one thing to know about these bills is, I just want to make sure I'm saying this right. Okay, maybe not. I think maybe it's restricted. These two anyways are restricted to physical or medicinal procedures. Because we still have the question of therapies, talk therapy, different things like that. Utah has a rule that's banned some of that. But being aware that if there's, just being aware that there are still some serious complications, including children born at birth with both parts, male and female parts, that happens. It's rare, but it does happen. And we still don't fully have a way as a society to address those situations and what to do. And so I think these types of laws will need refining over time. And one of the things that Kennedy's bill does, SB 16, is he proposes to create a committee to do some more research and make recommendations.
Interesting.
Which I think, again, we have to be wary of who's on those committees. Is it a good cross-section? Is it good representation and things? But I do think as a society, we need to continue to have discussions. In general, my opinion is we shouldn't be doing surgical or medicinal procedures on children. But there are a few situations where it may really benefit a kid that's growing both parts or has some of those concerns that they
Sure.
need some help.
So which bill would you be more comfortable with?
I haven't read through all of them completely yet. So talking as a general general principle, I think SB 16 to me is more comprehensive
Okay.
than HB 132. And I'm a fan of trying to tackle the bigger issue, I think. As again, as a general thing, because we still have a big issue with 18-year-olds or 19-year-olds or 50-year-olds or whatever.
Mm.
And not to say that, again, it gets this individual liberty thing of, well, if I'm an adult, can I do whatever I want to my body, change it however I want? It's a very complex discussion of rights and, again, responsibilities, and really delving into some of that. But I think, at least to me, SB 16 is trying to keep that discussion open, trying to get to a better place of understanding. Because it talks about I guess they're assigning the Department of Health and Human Services, but they're supposed to conduct a systematic review of the medical evidence regarding hormonal transgender treatments and provide recommendations to the legislature. I would love for others to be involved in that as well. But I think it's good that we're saying this is an ongoing issue. We need to study it, check it out, and see if we can get to a good place.
Awesome. So HB 281, I don't know that we have time. I think there's only about 5 minutes left. But I would love to get your opinion on that tomorrow night. It's Wednesday at 7, right?
Yeah.
Is-
You say
right?
HB 281?
HB 281, it was just numbered. It's not very
The
long.
social credit score amendments.
Yeah.
Let's see. See, prohibitions. Governmental entity may not use, enforce, provide data for use in, or otherwise participate in the creation or use of a system that, based on a social credit score, discriminates against, advocates for, or causes adverse or preferential treatment of a person. So this is something saying, hey, Utah government. Well, it does two things. It's a little funny. They're establishing a way to receive reports of the private sector's use of a social credit score. And then they summarize the reports received. So it sounds like the committee wants to get ongoing reports of how the private sector is using these. And then they're banning the government from using it.
the-
And
Sector can, but the government can't?
currently, yeah.
Interesting.
But I think the purpose of them getting reports is to see whether they feel it's becoming abused and if they need to do something about it.
So it's not really stopping it. It's just saying it's not stopping it in the private sector. It's just the government sector.
Correct. So
Interesting.
they can't say you have to have a certain score to get a driver's license,
Got it.
or you have to have a certain score to come into court today. And my bet is for most government functions, these social credit scores will never really kick in because it could very well violate due process and other constitutional rights. But it could kick in things like HB 215, where they say, hey, if you want to receive funds, you have to be a good, citizen. You don't have to receive funds, but if you want to get a good social credit score. But in general, for core functions of the government that's mandated by law, I think they'll have a hard time implementing it. So this is kind of a way, I think, to tell people, oh, we've got your back, but we're preserving freedom. But it doesn't really do much to change what's really happening.
So how is it okay that private companies can do that? I
So it
mean,
goes back to the same
all
thing of
past
saying,
thing. Okay.
if I want the freedom, I can say to someone, hey, I only want to let people in my home who have done service hours this week, right?
Yeah.
And so the companies can say, we're big and mighty and powerful, and we'll only do business with people who do X, Y, and Z to further the world. And
Wow.
we
Yeah.
say, well, if that's what you want, that's one thing. But the way it's being used is banks are being pressured to only lend to companies that satisfy these scores.
Mhm.
And again, could a bank choose that? Could they not? Well, our banks are so quasi-governmental anymore with all the bailout funds and everything else received. Are they really private? Is it really some individual choosing something? Or is it a whole host of people voting to take away certain rights from other people? And I think we need to start to have a serious discussion about a truly private business that's just owned by a person. They have a deep concern for what they're trying to evidence or put out there versus a public company that has no private ownership. I think there's two very large differences in what rights should apply in those situations. But we don't really talk that way very much. We just assume all businesses are the same, and we treat the Googles of the world the same often as the one or two person business.
Mm.
And I think there's a very clear line to draw a distinction with, well, are you privately owned or publicly owned?
Yeah.
And start to talk about some of those protections that might need to apply.
So the bill, it's pretty weak.
Yeah, it doesn't
Doesn't
do
really
hardly anything that the Constitution doesn't already do. So
see. Okay. Well, shoot. Well,
Is
thanks.
there,
that.
is there anything that the state is doing or even can do, given that it's probably going to be a federal mandate or something for these social credit scores, the digital ID? I've kind of lost track of the digital driver's license. Is that still active? Do
yeah,
you know? It
yeah, it's
is?
still active, still gaining more and more traction, and we're very much moving in that direction with.
Which bill is that? Do you know?
I don't. So I'd have to look and see if a bill has come out specifically on digital driver's license amendments. But last session there was quite a bit on it,
Yeah.
and I know that it's still gaining a lot of steam. I know someone presented on it. I didn't get to hear their presentation, but I can try and see if I can do a little digging. There's a lot
Yeah.
of bills still to be released.
Mhm.
I'm really concerned about that because that's kind of the first step to the digital, the digital prison that it looks like we're heading towards.
Well, the feds start rolling out the Pay Now system, I think in May. We're going to take over. Yeah, I mean, it's just all these different pieces that are just out there that are, I think there's eventually obviously going to try and merge it all. But
Well, Utah's been pushing very aggressively to even merge all their databases. And so there is a bill right now that one person's proposed the number, sorry, but they proposed to force the government to disclose what databases are connected.
Oh, interesting.
Because there's a lot of connected databases. And so I don't know if that one will fly and get anywhere or not, but I think it'd be very interesting for us to know all the connections that exist between all the databases that are there. But that is something, but again, it cuts both ways in the sense of, you know, if the IRS knows something about me and the business licensing division knows something about me, does that violate due process? Does it not? Does it make our system better? Does it make America cleaner? And we have all these concerns because what happens right now is private companies know this stuff about us. They're connecting all the dots. And the government currently has the right to just ask them for records and say, hey, hand it over. And so then, to me, we need a very different discussion about checks and balances on databases and privacy and all kinds of things the founders could have never, I don't even think, dreamed of or thought of. Because there is a high concern if the private sector can do everything and connect all the dots and get all the data, then the government can just request it at any time. It's not very different than the government having the data itself. And I'm not saying that that just means we give the government the data. I'm saying that means we need to have a very serious discussion as a society about, are there some rights that should apply? If, you know, is privacy something that we need to look at protecting a little differently than we have in the past? Because there's a lot of high concerns around what's going on.
For sure.
So some of the fun discussions we need to have, but yes, we will need to jump off. I will be at the Capitol in a little bit. I'm not in the committee hearing you were talking about. I'm in a different committee hearing today at 2. But that will be fun.
Sounds like you
And
run for office.
no. No, office is a very different place.
Yeah.
So I think that citizens often underestimate the value of being a citizen and being involved. There's a lot of power to it. And you need certain people in office for sure, but we need citizens as well. So I'm on the citizen side right now.
Thank you so much.
Yes, this is
I
so
love
helpful.
this. Yeah, so helpful. Appreciate your
Okay,
willingness.
but we will go. Yeah, no problem. But we'll go through more of this tomorrow night
Okay,
and meet again then. So thanks
thank
for
you.
being involved.
Bye.